Hello aspirants, here I am Pallavi Rai and today we will discuss about Commercial Code Act 2015, and the session for today is based on the section 13, which deals with appeal. And section 13 says that appeal from decree of commercial courts and commercial division. It attached three subsections, which is first A and 2, and here are. So before discussing the chart, we will go through the Bear Act and see the provision what is given in the Commercial Code Act. So if we see subsection 1 of section 13, we could see that if any person who is agree with the judgment judgment of the court which is below the level of district judge, court which is commercial court which is below the level of district judge may appeal to the commercial appellate court within a period of 60 days from the date of judgment or order. So if we could relate it with diagram, what we could see here that the commercial court which is defined under section 2b of definition clause, and its construction is given under section 3 of Commercial Code Act. So if we could relate it, we could get the provision very easily, and its appeal goes to the Commercial Appellate Court which is defined in definition clause 2a, and its constitution is given under section 3a of Commercial Code Act. So it is very clear. It is very clear that appeal of commercial court below the district judge level goes to the commercial appellate court. So, and its appeal goes from the judgment. It appeal goes within 60 days from the judgment. It's clear. Now we will move on to the next subsection 1. What subsection 1 says that if any person agree by at the level of district judge, if any person who is aggrieved by the commercial court at the level of district judge or a commercial division of high court may appeal to the commercial appellate division of that high court within a period of 60 days. So we could see in the second box, second part of box, in which it is mentioned that commercial court at the level of district judge and commercial division of high court which is defined in 2d, and its construction is given under section 4a, and its appeal goes to the commercial appellate division of that high court which is defined under section 2aa of definition clause, and its constitution is given under section 5 of Commercial Code Act. So if we go through this chart, we could easily get which court's appeal goes to which court and what is that court, in which section it is defined, and what is the constitution of that court. We could very easily get all the provisions. So next we will move on to the proviso which is attached with subsection 1a of section 13. What proviso says that if any appeal shall lie from such order passed by commercial division or commercial court that are specifically enumerated under order 43 of CPC as amended by this act and section 37 of Arbitration and Conciliation Act. What does here means? That by virtue of section 37 of Arbitration Act and by virtue of this act, if any order has been made by commercial division or commercial court, and that order are specifically enumerated under order 43 of CPC, its appeal shall lie. Okay, proviso of 1a says that generally appeal of district judge level of commercial district judge level of commercial court and commercial division of high court may goes to the commercial appellate division. But here in proviso it is said that by virtue of section 37 of Arbitration and Conciliation Act 1996, and by virtue of this act, whatever amendment has been done in CPC, and the provision which is provision which is enumerated in order 43 43 of CPC, whatever order what order 43 says. Order 43 says that appeal from orders. Order 43 contains appeal from order, and there are following orders under which under the provision of section 104 an appeal shall lie from. So the proviso of subsection 1 of section 13 of Commercial Code Act says that appeal shall lie from such order which is enumerated in order 43 if that order is given by commercial division or a commercial court. Okay, it is clear. So now we will move on to the subsection 2. What subsection 2 says that notwithstanding anything contained in any other law or latest patent appeal of High Court. Both of these are exceptional provision, whatever mentioned in that, but it is contrary to the provision of Commercial Court Act. It doesn't matter, because whatever provision of appeal is given in this act shall prevail, and not it shall not be dealt with otherwise than in accordance with the provision of this act. So subsection 2 says that notwithstanding anything contained in any other law or latest patent appeal of High Court, no appeal shall lie from any decree of commercial division or commercial court otherwise than in accordance with the provision of this court. So section 13 is very clear from this chart that if according to section 1, according to subsection 1 of 13, aggrieved party from the judgment of commercial court below the level of district judge may appeal to the commercial appellate court, and aggrieved party from the judgment of commercial court at the level of district judge and commercial division of High Court may appeal to the commercial appellate division of that High Court within a period of 60 days. The period stipulated in section 13 is period of 60 days. So you must aware from, because it may ask in examination. So please learn the 60 days of period which is stipulated within which you may prefer an appeal to the appellate court. So now we will move on to the definition of that court and constitution of that court. So first we will discuss about the constitution of commercial court, which is defined under section 2B, and its constitution is given under section 3. So if we see the very first subsection of this section, section 3, we will see that the state government has the power after consultation with the High Court to constitute such number of commercial court at district level. So the state government is authorized, state government is empowered to constitute such number of commercial courts at district level, but it is not absolute power. That state government has to constitute after the consultation with the High Court. So here is proviso annexed with that subsection. What the proviso says that with respect to the High Court having ordinary original civil jurisdiction. If we see this line, the word having ordinary original civil jurisdiction in respect of High Court, we are very confused, because we have already we are already aware that High Court is an appellate court and it doesn't have any ordinary original civil jurisdiction, but here is mentioned. So the answer of this question, that having ordinary original civil jurisdiction in respect with High Court, so there are the 5 High Courts in India which has original civil jurisdiction. The High Court of Delhi, the High Court of Himachal Pradesh, the High Court of Kolkata, the High Court of Madras, and High Court of Bombay. These high courts have ordinary original civil jurisdiction, and in respect of that high court, in respect of Delhi High Court, Himachal, and Madras, Bombay, state government may, after consultation with that high court, constitute commercial court at district judge level. Okay, now it's clear. But but here is a proviso, another proviso annexed with that subsection, that but whatever the pecuniary jurisdiction of this court, which is constituted at district level, must not be supersede the pecuniary jurisdiction of civil matter. Whatever civil jurisdiction has been provided, whatever pecuniary jurisdiction in civil matters are provided to that courts, must not supersede. Okay, because we are aware that from the amendment of 2018, the pecuniary jurisdiction of pecuniary jurisdiction of that commercial courts are not less than 3 lakh. So the minimum pecuniary jurisdiction of these courts are 3 lakh, but it doesn't supersede the pecuniary jurisdiction of civil matter. If pecuniary jurisdiction of civil matter of that court is 5 lakh, so we could not give him the jurisdiction more than 5 lakh. It will be from 3 lakh to 5 lakh. Okay, now it's clear. Its next subsection 1A says that state government may, after consultation with High Court, specify pecuniary value which shall not be less than 3 lakh or such higher value. So state government is authorized to specify the pecuniary value. It is discretionary power, but it is not absolute. He has to exercise this power after consultation with the High Court. Now we will move on to the subsection 2. In subsection 2 of section 3, state government may, after consultation with High Court, specify the local limits. Local jurisdiction, pecuniary jurisdiction is the state government is empowered. State government is empowered regarding pecuniary jurisdiction, local jurisdiction. So it is the power of state government, but it is not absolute. That government has to do with the consultation of High Court. Now we will move on to the subsection 3 of section 3. State government, with the concurrence of Chief Justice of High Court, appoint one or more person having experience in dealing with a commercial dispute to be the judge or judges of commercial court, either at the level of district judge or a court below the level of district judge. So according to subsection 3 of section 3, state government is authorized again with the concurrence of Chief Justice of High Court. This power is also not absolute. It is also with the concurrence of Chief Justice of High Court. State government may appoint one or more person having experience in dealing with a commercial dispute to be a judge of commercial court. Okay, now it's clear. So I think there must not be a confusion regarding the constitution of commercial court, and its appeal goes to the commercial appellate court, which is defined in 2A. Now we will discuss about the section 2A and its constitution which is given under section 3A. So let's get started. So now we will discuss about the commercial appellate court, which is defined in 2A, and its constitution is given in section 3A. What section 3A says? Section 3A says the designation of commercial appellate courts. From the lines of, if we go through the Bare Act, we could see that except the territories over which the High Court having ordinary original civil jurisdiction. except the 5 high courts which have ordinary original civil jurisdiction. The state government may designate such number of commercial appellate court at district judge level. So it's clear from section 3A that designation of commercial appellate court, whatever high courts, whichever high courts who has ordinary original civil jurisdiction, except these 5 high courts, the remaining high courts, from the remaining high courts, state government may designate such number of commercial appellate court at district judge level as he thinks fit, as it may deem necessary. So it's all about section 3A. Now we will move on to the next definition, which is of commercial division of high court, which is defined in section 2D, and is constitution of commercial division of high court is given under section 4. So what first subsection of section 4 says, in all high court having ordinary original jurisdiction. High courts having ordinary original jurisdiction means Delhi, Himachal, Madras, Bombay and Calcutta High Court. The CJ of High Court may by order constitute commercial division having one or more benches consisting of single judge for the purpose of exercising jurisdiction and power conferred. What does here means? That high court that have ordinary original jurisdiction, and CJ of that high court, which high court have ordinary original jurisdiction, may by order constitute commercial division having one or more judge, one or more bench, whether it is of one bench or 2 or 3 bench, but these benches must be consisting of single judge for the purpose of exercising jurisdiction and power conferred. In subsection 2, the CJ of that high court shall nominate its judge of high court who have experience in dealing with a commercial dispute to be a judge of commercial division. And now we will and it's all about section 4 and constitution of commercial division in respect of that high court which have ordinary original civil jurisdiction. Now we will move on to the next definition, which is provided under section 2AA, commercial appellate division of that high court, and its constitution is provided under section 5 of that act. What section 5 says that? Section 5 says that constitution of commercial appellate division of that high court. Under section 5, subsection 1 says that after issuing notification under section 3 subsection 1 and after order under section 4 subsection 1, the CJ of high court shall by order constitute commercial appellate division having one or more division bench for the purpose. Commercial division of high court consisting single bench, single judge, one or more bench consisting of single judge, and commercial appellate division of that high court having one or more division benches for the purpose. What does division benches means? There must be minimum 2 judges. Now we will move on to the subsection 2 of section 5. CJ of High Court shall nominate such judge of High Court who have experience in dealing with a commercial dispute to be a judge of commercial appellate division. So the Chief Justice of that High Court is empowered to nominate such judges of High Court who have experience in dealing with a commercial dispute to be a judge of commercial appellate division. So it's all about the definition of courts, constitution of that court, and and how many days appeal goes to which court. Now we will move on to the very important section of Commercial Courts Act 2015. And why did this act we need? Why did it come into existence? It is the answer of existence of this Act. Section 14 deals with expeditious disposal of appeal. Actually, prior to the Commercial Code Acts, the civil courts deal with all the commercial disputes, and the process of civil court procedure of dealing with the civil matters are very slow, very time taking. There are many provisions like appeal, revision, review, and many more procedure are given to eradicate, to eliminate the error given in judgment, and uh, and the defect of judgment. The party aggrieved have many more remedies to deal with the to deal within civil matters. But when Commercial Court Act 15 came, it the time taking procedure has been eliminated, and the revision process has been eradicated from the Commercial Court Act in commercial disputes, and